Hey everybody, welcome back to another episode of Hail State Debate, the greatest YouTube debate channel in the entire Starkville metropolitan area. We are kicking off a new calendar year in 2024 with a brand new PF topic: resolve the United States federal government should repeal Section 230 of the Communications Decency Act. We're shooting this over the holiday break, and that means Devin and Tanner, our normal co-hosts, are unfortunately not on campus, but they did a fantastic job of helping me research this one, and they'll be back for the February topic. But in the meantime, we are soldiering on solo. So if you are a regular viewer, you know the drill on this channel. We want these videos to be useful to you, so we put all the timestamps and links to all the sources in the comments below. If it's useful, maybe like, maybe subscribe, maybe tell a friend. Those things help us reach more people, and the whole idea behind the channel is that everybody should have access to good information and good coaching in high school debate. Now, because I'm flying solo, we're going to use a somewhat more abbreviated top 10 points format for this video. 10 things that you really need to know, covered a little bit more quickly than one of our full videos. Very briefly, as for my thoughts on the topic, I think it's like okay. It's not my favorite. The subject matter generally is fantastic. Section 230, as we'll talk about, is a law that insulates participants in online speech, whether they're platforms like Google or Facebook or websites like Wikipedia or individual users, from many types of legal liability for what they say or allow to be said on the internet. The issue generally of like toxicity and harassment and misinformation, even illegal activities like trafficking and terrorism on social media and on the internet generally is incredibly timely, incredibly important. So there are two reasons why I don't love this specific topic, though. The first one is the word repeal. As we'll talk about later in the video, Section 230 is such a fundamental pillar of how the internet operates that repealing it would be like, as one commentator said, using a chainsaw to do brain surgery. So it's a very extreme solution to the problem. And the second reason, which is related, is that it's a topic that requires us to predict how a lot of different actors like online platforms, nonprofits, courts, individuals, and so on are going to react when we yank this very important security blanket that's been around for decades now away. And that's just a really, really hard prediction to make. As we'll talk about later, for example, there are at least like two diametrically opposite responses that we might see from online platforms in response to getting rid of Section 230. And it's just really difficult to link to big impacts when we don't really know what even the biggest players would do in response to a policy change like this. I will say, though, that every crisis presents an opportunity, and the opportunity here is to get really good at like logically explaining your evidence and your links and giving practical examples of what might be gained or lost. Because hey, your judges are online too. They see how social media works. They see how the toxicity online is. They understand it firsthand. And if you can generally do a great job of storytelling and not just reading cards, you can really have an advantage. So anyway, I'd say, it's a B- type resolution. Could be better, could be worse, but you've got to debate it. So let's jump right in and look at point 1 of 10. What is Section 230 of the Communications Decency Act? So as you probably already know from some of your initial reading on the topic, Section 230 is a provision of a U.S. federal statute called the Communications Decency Act, or CDA, of 1996. And the point of Section 230 in a nutshell is to carve out an exception to the general rule of the CDA, which in some cases would create criminal liability for online publishers of things that the act considered indecent, like, for example, pornography. Section 230 said that providers of what it called interactive computer services, which at the time were things like message boards and chat rooms, were not considered the publishers of whatever their users might post online on their sites. So those providers couldn't be held legally liable if, say, one of their users posted something illegal or legally actionable on their bulletin board or on their website. So if you want the really short version, Section 230 is important because it provides legal protection for companies that host online forums, ranging from the very basic message boards of the 1990s to the very sophisticated social media of today, so that they can open up their platforms, whether it's Facebook, TikTok, Twitter, whatever, to free expression without worrying that they might be held legally liable for what their users say. Now, that's the very short version, but if you will indulge me as a former recovering lawyer for just a minute, it's actually a little bit more complicated than that. And it's worth taking maybe, 2 minutes to understand the background. So the Communications Decency Act was passed in the mid-1990s when parents and Congress were increasingly concerned that the internet was making it easier for people, specifically easier for kids, to access like sexual or otherwise indecent materials. And to be fair, it certainly was doing that. So when it was passed in 1996, the CDA imposed criminal penalties for displaying online any material that was, quote, patently offensive as measured by contemporary community standards if it was available to people under 18 years of age. And as you know, even at that time, pretty much everything on the internet is easily available to anyone, including people under 18 years of age. Now, in the long run, the indecency part of the CDA, like the core of the CDA, didn't really matter much because it almost immediately got struck down by the Supreme Court on free expression grounds. In late 1996, a case called Reno versus American Civil Liberties Union was filed. The lower courts held that under the First Amendment, the government couldn't criminalize things like pornography or indecency. And in 1997, the Supreme Court agreed and struck down the indecency provisions of the CDA. So at this point, most of the CDA, the main point of the law, is basically gutted. They would amend it later to add some provisions about obscenity, but obscenity is very, very difficult to show. So it essentially makes the CDA today more or less a dead letter. It's not something that we actually prosecute people under. So you might be wondering, well, okay, if Section 230 was just an exception to the Communications Decency Act, and the rest of the Communications Decency Act is now dead, then why does Section 230 still matter at all? And the answer is that the protections of Section 230 went beyond just protecting these providers of computer services from being charged under one specific statute. They didn't just protect you from being charged under the CDA specifically. Instead, they protected these providers from a much wider range of legal threats that still exist today on the federal level and in every single state, which is why Section 230 is still critically important today. So this is the part where we learn what Section 230 actually says, which is important. The details matter. They make you sound smart. They help you avoid easy mistakes. So the key language in Section 230 is this: no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. These are the words that were referred to by historian Jeff Kosseff as the 26 words that created the internet, because they allowed people and companies to open up their websites to largely unregulated discussion without fear of being sued. Now, again, the key words in Section 230 are publisher or speaker. So for many different types of legal claims that are related to harmful speech or expression, for somebody to be liable, whether it's a person or a company, they have to be considered the publisher or the speaker of the content. For example, defamation is making an intentionally or recklessly false statement about somebody else. So if I went on TikTok and made a video falsely accusing you on cheating on your exams or cheating in debate, well, then you could sue me for defamation because I'm considered the speaker. I'm the one who hit post and said it in my TikTok video about you. But under Section 230, you could not sue TikTok merely for hosting the video. And it's not just defamation. It could be posting threats online. It could be harassing someone online. It could be sharing someone's private information online in some cases. It could be all kinds of potential legal claims. And by the way, it protects you in every court in the United States, not just in federal courts, but also in state courts. And that's because subsection E3 of Section 230 says this: nothing in this section shall be construed to prevent any state from enforcing any state law that is consistent with this section, but no cause of action may be brought and no liability may be imposed under any state or local law that is inconsistent with this section. So, for example, if the state defamation laws or the state privacy laws in New York or Mississippi or Texas would allow you to sue these tech companies for what other people post, it doesn't matter because those state law claims, just like federal claims, have been what we call preempted by Section 230. And preemption is just the idea that when a federal law, like this statute, like the Communication Decency Act, conflicts with a state law, the federal law wins. And in this case, Section 230 wins and prevents lawsuits on basically any level, federal, state, even local courts. Now, to be clear, that doesn't mean that Section 230 protects online platforms from every possible type of lawsuit. There are a couple of exceptions, and these are under subsection E of Section 230. So, for example, Section E1 says that 230 doesn't protect against federal criminal prosecution. So, for example, there are federal criminal laws about things like sexual exploitation, terrorism, trafficking that could impose criminal penalties for online platforms if they, for example, aid in the commission of a crime. Section 230 doesn't undo those. So if there's a federal criminal law that would make you liable for hosting, say, trafficking information knowingly, well, Section 230 isn't going to protect you. It doesn't give you a pass. Additionally, under Section E2, it also doesn't affect intellectual property laws, which sometimes can hold online platforms liable if they don't take steps to stop things like copyright infringement. So, for example, this is why the platform we're on right now, YouTube, has a very robust system of copyright protection. If you include a copyrighted song in your video, which we did one time several years ago, YouTube's algorithm will find it immediately and it will pull it down until it decides whether it's permissible, because YouTube knows that it could be sued because that's intellectual property law, which is expressly not protected under Section 230. And lastly, under Section E4, it doesn't affect communication privacy laws, like laws that prohibit like intercepting or storing certain user information. So Section 230 is not an absolute a blanket protection, but it is really broad, and it is a law that has stood the test of time. It's over 25 years old, which is an eternity in internet years, and the Supreme Court has been very reluctant to limit it in almost any case, partly because it's really broad and partly because these justices, who are, even older than me, will tell you that they are not tech experts and frankly don't feel terribly comfortable trying to interpret it. And we will actually link to a summary of a couple of Supreme Court cases from 2023 in which the court could have potentially taken some steps to limit Section 230, but decided not to. So anyway, that's a really basic summary of what Section 230 is, which segues nicely into our second point. Point number 2, what happens if we repeal Section 230? Well, the short answer is that is a really, really good question that leaves real-world policy experts very much uncertain. We really just don't know the answer to that. This is a resolution, as we said earlier, that asks us to imagine a world where this really essential rule that huge companies, individuals, nonprofits, governments, everybody has built their operations and in some cases their lives around, and it just disappears. Well, what happens? How do they react? What rules get made to fill the gap? Who makes them? Do some of these providers and platforms just take their ball and go home and shut down because they can't live in a post-230 environment? Well, the answer is we don't know. We can guess, and in a second we'll look at some very good sources that do make educated guesses about a post-Section 230 world, but again, they are just educated guesses. And as we'll talk about later, for me, one of the core themes for the con is going to be, Judge, look, you just have no idea what you're going to get when you hit that button, when you vote pro and get rid of Section 230. You're just guessing, and that's a dangerous thing to do. You could get a world where online platforms clamp down and over-restrict speech that's not harmful, that should be allowed, or you could get the exact opposite, a world where they look at legal precedent, which we're going to talk about, and decide, hey, the best way we can avoid being liable for being a speaker or a publisher is to just go completely hands-off and not moderate anything. Or some of them, including some really important ones that we'll talk about later, like Wikipedia, they might just shut down, and we might lose their benefits entirely. Or maybe, again, talk about this in a second, the Supreme Court might step in and say that the First Amendment protects these sites. So there might not be very much change at all. Which one will it be? Which combination will it be? Where along the various spectrums will it fall? The answer is we don't know. It is very much a dice roll. It depends on thousands of decisions by state and federal courts, private companies, state legislatures, individual users, and so on. And so, as we'll talk about later, voting pro just unleashes chaos is a pretty compelling general theme for the con. You don't know what you're going to get. But that doesn't mean that there aren't smart people out there making educated guesses. So let's take a look at what some of them are saying. And in fact, one article that I'd say is required reading on the topic is one from Derek Bambauer of the Brookings Institution called "What Does the Day After Section 230 Reform Look Like?" And in it, Bambauer says right off the bat that any major change or repeal of Section 230 would create chaos. But then he tries to sort of game out what the most likely next steps would be based on the incentives that the various platforms have, based on other existing laws, and so on. So the first thing he predicts, which I think is undeniably correct, is that we will see tons of litigation and the courts will get involved in creating new rules for when a company or a user can be liable for online information that they didn't write, that they didn't create, but they published or put there, and to fill the gap in Section 230. We know that they will do this, incidentally, because, as we'll discuss later on the con, this is exactly what courts were doing back in the 90s, right before Section 230 was passed. They were trying to wrestle with the legal question of like what liability would look like on this newly created thing called the internet. And if we repeal Section 230, they will have to pick up right where they left off. Now, I'm not going to read Bambauer's full quote, but I'm going to pop it up on the screen. The bottom line is everybody will sue everybody else, and we simply cannot predict what the results will be. Now, the second thing Bambauer predicts, and also something I think is pretty likely, is that a country with 50 different state court systems and 50 different state legislatures is going to have a bunch of internal contradictions and conflicts in terms of what the new rules will be. As the article explains, different courts are likely to come to different conclusions, an undesirable outcome for global sites that would prefer to enforce consistent rules. While the U.S. Supreme Court might ultimately resolve some disputes, such as over First Amendment claims, others, such as state-based contract doctrines, do not fall under its purview. Variegated laws on the same internet subject make it difficult and expensive for national entities to comply fully, as past experience with anti-spam rules, privacy laws, and the contours of Section 230's exception for intellectual property have demonstrated. So as we'll talk about later, this is another knock against the pro, which is the idea of inconsistent rules. It's hard for any company, even big companies, much less small startups or individuals, to try to comply with 50 different sets of legal standards. It's probably impossible for the smallest companies and the smaller ones who are trying to start up and challenge the big players. It's probably impossible for nonprofits like Wikipedia. And that raises the con argument that repeal would only cement the dominance of the biggest tech firms like Facebook and Google, because they're the only ones who can afford the battalions of lawyers and the staff needed to comply with all of these different rules. Which, if you want lots of competition and choices for free expression online, that would be a very bad outcome. But in the long run, Bambauer makes a prediction that maybe not all that much would really change from repeal. Now, I don't think I agree with this conclusion, but let's hear him out. Because this could be a useful bit of context. He writes, in the long term, perhaps surprisingly, the content of social media ecosystem will probably look similar to that available in the current environment with Section 230. This is because Section 230 is in significant fashion a statutory clearinghouse for constitutional concerns based on the First Amendment. And he goes on, as you can see here, to argue that the Supreme Court, when it has looked at free speech online, has been very protective of it. So what he thinks is maybe if we repeal Section 230, the Supreme Court would swoop in and say, no, sorry, states, your defamation laws, your other legal claims that you're going to allow people to use to sue these companies, those are all barred by the First Amendment. Now, I don't know if I necessarily agree with this. My personal take would be, yeah, I guess that the Supreme Court probably would find some First Amendment protection for social media platforms and websites. Yeah, that's probably true. But the problem is it won't be anywhere near as absolute as Section 230. It won't be, you are not liable for what users post, period, which is what Section 230 does. It will be something more like, you aren't liable under certain circumstances on certain conditions, which is how most First Amendment legal rules that come from the courts tend to work. And that means this protection won't be as predictable or as reliable, which in turn means a lot of these companies will have to resort to other methods that we'll talk about later to protect them. Anyway, the bottom line, this is a resolution where to link to any impact, you're going to have to tell a story about how companies and individuals and maybe even courts are going to react to a post-Section 230 world. If you have a card that says tech companies will do X and your opponent has a card that says no, they will do Y, but then they explain logically why they will do that. And they give some examples of why it's only logical that they would do that. You would do the same thing if you were in their shoes, Judge. They're going to be getting their impacts across to the judges better than you are. So evidence is key, but using that evidence to explain the logical incentives and why people are likely to do what you're saying that they will do is absolutely essential. And we'll spend a lot of time talking about how these stories go in just a few minutes. In fact, why don't we just go ahead and jump in right now to our first substantive point on the pro, which is point 3, repeal improves content moderation. Now, I think it's fair to say that no other industry in the world has the same kind of blanket legal protection for the core function of what it does that internet content providers and social media providers have in Section 230. It would be very much like if the chemical industry had a blanket law that said you can never be liable for air pollution, right? It basically removes any legal incentive whatsoever for these companies to take responsibility and take action for what gets posted or promoted or featured on their site. And maybe the pro would say, maybe this was understandable in 1996 when we wanted to spur the growth of the fledgling internet and really had no idea like how harmful or toxic this content could be. But now, almost 3 decades later, we have a flourishing internet, but in many cases we have some very weak content moderation standards that either allow or at least fail to prevent everything from misinformation and harassment to outright crimes like sex trafficking. And so the core idea behind arguments to repeal Section 230 is that it would force online platforms from Facebook to Reddit to Wikipedia to Twitter to get serious about how they detect and remove harmful speech. Now, to make this argument work, first you have to show that moderation in the status quo is bad, and there's plenty of solid evidence. For example, this is from Paul M. Barrett of the NYU Stern Center in an article called Who Moderates the Social Media Giants? And it says, today, 15,000 workers, the overwhelming majority employed by third-party vendors, police Facebook's main platform and its Instagram subsidiary. About 10,000 people scrutinize YouTube and other Google products. Twitter, a much smaller company, has about 1,500 moderators. These numbers may sound substantial, but given the daily volume of what is disseminated, they're grossly inadequate. Having several thousand workers sounds like a lot until you realize every single day, Facebook alone sees 4.75 billion posts. So if, say, just like 7 million of those, or like less than 0.25% got flagged and reported, that would mean that every single one of Facebook's 15,000 reviewers would be looking at and making decisions on 500 questionable posts per day, and that's just not possible. And it's not just the sheer number of posts, it's also the complexity and the ever-changing ways that people like extremists and these disinformation farms in Russia and others frame their content. So this is from Abby Wallace in October of 2021. And it says, dangerous content circulates online because it's increasingly difficult for content moderation tools to pick up on harmful discourse. This is because those perpetuating it are constantly exhausting new methods of getting around moderation tools, such as symbols, memes, and emojis, which are increasingly being used to mask hateful speech. By the time violent extremist content reaches mainstream platforms like Facebook and Twitter, it is sanitized to the extent that it doesn't trigger content moderation tools to step in. And you don't have to take my word or her word for it. There's a great article by Ina Fried in Axios in 2023 where Facebook just tells you about its inadequate moderation. And it says in March 2020, Facebook warned that due to a lack of content moderators, it was relying more on AI to triage user reports. Some content flagged for breaking rules, the company said, wouldn't get reviewed by a human at all. Today, Facebook continues to show that message to an unspecified number of reports deemed as a lower risk by its automated tools. Australia's e-safety commissioner Julie Inman Grant told Axios via email that her agency saw a 600% increase in illegal and harmful content on both Facebook and Instagram during COVID. Levels of harmful content have dropped since the peak of the pandemic, but this year has seen an increase across all social media platforms in both child sexual abuse material and specifically in image-based sexual extortion. And we could spend the entire video giving examples of like poor or non-existent content moderation. Twitter/X under Elon Musk has made a very elaborate show in the last few months of welcoming hate speech, harassment, misinformation to the platform. He reinstated people like Andrew Tate, Kanye West, Project Veritas, and Donald Trump. And without belaboring the point here, having some specific concrete examples of like this terrible toxic online content to go with your more general evidence is a good idea because again, your judges are online, they're familiar with the toxicity, and reminding them of the stuff that makes its way through, like in specific terms with examples of the stuff that makes it through these inadequate filters is really important. On that note, the Barrett piece we cited earlier also mentions that Facebook moderators have to collectively understand more than 50 languages because the platform supports more than 100. And the report goes on to detail the impact of just like this language gap. It says the number of incidents like calls for genocide in Myanmar, anti-Muslim violence in Sri Lanka, Hindu nationalism in India, where Facebook's third-party moderators were totally useless. Real, tangibly harmful, violent, and illegal speech was allowed to spread like wildfire on these platforms because they simply had a problem that they were not logistically prepared to tackle. The simple solution now, according to the pro, is to take away this unprecedented blanket protection from liability of Section 230 so that these online companies are subject to the same incentives that every other company in the world has to make their content providers, that they have to start spending the money and doing the investment to make their moderation more effective. Maybe through human content moderation, maybe through adjusting and strengthening their algorithms, maybe through other things. If you want a card from this, there's this from Mark Zahn of ABC News in 2020. And it talks about how a hypothetical high court decision affecting Section 230, but the arguments are the same if we were to legislatively repeal it. It says a high court decision that eliminates legal protection for recommended content could significantly alter the types of posts that appear before users on Facebook's newsfeed or Twitter's timeline, said Eugene Volokh, a professor of law at the University of California, Los Angeles. Sites would be a lot more cautious about those types of recommendations, Volokh said. Whenever they see something that might be potentially dangerous for them, they'll exclude it from recommendations. Posts that could concern social media sites after the ruling include libelous comments and instructions for committing criminal acts, not just the terrorist propaganda at issue in the Supreme Court case. The basic takeaway here and the key talking point for the pro is that Section 230 is like this weird outlier. It's something no other industry has that protects it almost completely from being held accountable for the predictable results of its business model and the predictable results of things that it allows to be put on its platforms. When pharmaceutical companies know that their product is addictive and they do nothing, they can be sued. When car companies know that their cars are dangerous when you drive them a certain way, they can be sued. Only tech companies get a special pass. They get a special pass that removes any legal incentives for them to go and improve their content moderation policies. So what we're asking for here as the pro is not some crazy draconian rule. We're just asking to remove a barrier in the form of Section 230 that prevents these companies from having to take the same steps that every other company in the world has to take to make its product less harmful and less dangerous and less liable to break the law. So with that, let's move on to point 4, another pro point, which is that repeal fights misinformation and strengthens democracy. So as we talked about earlier, one of the key things for the pro is being able to tell a clear, concrete story about like what is so bad in the status quo with Section 230. How can we improve it if it's repealed? Talking generically about how these companies are irresponsible is fine, but what you want is tangible harms that get put out into the world as a result of Section 230. And we're going to talk about a bunch of these, over time throughout the video, and I'm sure you're going to find plenty more on your own. Things ranging from like mental health for teenagers to outright criminal activity, trafficking, terrorist activity. They're pretty easy to find. We're not going to cover all of them, but I did want to take a second and highlight what I think is a really powerful impact that I would look at very carefully for most pro cases. And it's the benefits of repeal in terms of fighting misinformation and polarization and generally strengthening democracy. So we know that social media platforms are wired to provoke outrage and basically let people live in their own political bubbles where they only hear facts that confirm their own existing biases. So this is from Kevin Zhao of UC San Diego in 2022, and he says, and he's actually quoting a former executive at Facebook. He says, according to Tim Kendall, ex-director of monetization at Facebook, in other words, the person who's in charge of making money for them, Facebook intentionally uses Section 230 immunities to promote content that will provoke, shock, and enrage its users to maximize attention. This proves 2 points. First, social media platforms like Facebook form revenue in a way that is directly correlated to engagement time. And secondly, the use of incendiary content, including shocking images, graphic videos, and headlines that incite outrage, was internally recognized as a method to increase engagement times. Their algorithms trigger emotions to demand the most attention from Facebook's users. Because social media companies lack the incentive to moderate content, Section 230 immunities have instead encouraged them to turn to promoting sensational content regardless of its accuracy. This is a huge cause of misinformation's prevalence online and an easy source of a solution. So years ago, the internet and social media were touted as this brand new online town square. I remember people saying that back in the 1990s, where people could go and discuss and debate the issues of the day. But the reality is these town squares are becoming more like dystopias. They're run by for-profit companies who attract more views and sell more ads and make more money when people are screaming at each other and saying incendiary, outrageous, and sometimes outright false things, as opposed to when they're having a civil conversation. Another very clear explanation of this comes from Vanessa Otero of the Cornell Policy Review, and it says, Section 230 as it currently exists is wholly inadequate to address the problems created by how social media distributes content, namely polarizing content and misinformation. And she goes on to talk about how, as you can see here, I'm not going to read the whole thing, but their algorithms prioritize, suggest, selectively target, and display content that is meant to be questionable, misleading, problematic, false, bias confirming, polarizing, and extremist in nature, because they know that these are the things that are going to attract users and bring them back and keep them angry and keep them engaged. Now, the impact of this on the United States and on our political culture is massive. Americans are more polarizing and more mistrustful of our democratic institutions than at any point in modern history. So this comes from Gabriel Sanchez and Keisha Middlemas of the Brookings Institution in 2022. And we're not going to pull all this up here, but you can see there's a lot of data that talks about Americans are really concerned and afraid about political polarization, political instability, the divisions that we have where we view others as being the enemy. It talks about how this is driven by online sharing of false information, the big lie about the 2020 election being stolen, Russia's cyber efforts with online actors to promote disinformation. And basically, these platforms have no strong incentive to fight back against it. I mean, to be honest with you, Twitter and Facebook are probably beneficiaries of Russian misinformation farms, because those are the kind of things that get people angry and get them, coming back to Facebook and arguing online. So clearly, if we want people to continue to believe in democracy, to accept elections as legitimate, to not resort to like storming the Capitol or just living in their partisan bubbles and believing wild conspiracy theories, we have to do something about this polarization and this misinformation. But what can you do that has any real impact? There aren't a lot of good options. But you know what does work when it comes to fighting misinformation? Suing the companies that spread it. And you know how I know that suing companies that spread misinformation works? 2 words: Fox News. So Fox News, of course, is a television network, not an internet service provider, not an internet content provider primarily, right? So it is not protected by Section 230 for most of the things that you see on its airwaves. And after the 2020 elections, its presenters and hosts constantly repeated totally baseless claims about election fraud and interference, some of which happened to involve a company called Dominion Voting Systems. Fox aired false claims that Dominion machines somehow switched votes from Trump to Biden, so Dominion sued them for defamation and was gearing up to take them to a massive, very embarrassing trial when in April 2023, Fox News agreed to a $787 million settlement with Dominion. And if you want a good summary of that, we will post a link to a very clear AP summary of it. But here's the kicker. Do you know what Fox News does now with false claims of fraud and false election conspiracy theories? It doesn't air them anymore because it's afraid of getting sued again. And when guests repeat this misinformation, Fox cuts them off and corrects them. For example, there's this article from Lee Moran in the Huffington Post of December 2023. And it says, Fox News live broadcast of Donald Trump's speech at a campaign rally in Cedar Rapids, Iowa on Saturday was interrupted by a fact check from anchor Arthel Neville. Well, the former president finally got around to some campaign promises amid lots of cheering, as you heard. Many untruths, she pointed out. The 2020 election was not rigged. It was not stolen, Neville added, countering Trump's false claim that he won the vote against President Joe Biden. Now, you can also find examples of other extremely partisan networks like One America News doing the exact same thing, cutting people off and basically having its presenters read from a script to correct them and say, no, the election wasn't stolen. And yes, it's probably too late to change the minds of the viewers who watched these channels back in 2021. But the fact remains, these are very partisan, in this case, right-wing networks, but they could easily be left-wing networks too in a different scenario. And they are being forced to actively shut down false information that they agree with. So presumably nonpartisan companies like Meta and Google, these threats of lawsuits would be even more effective. Anyway, the bottom line is you can tell a really powerful impact story about eroding democracy with misinformation and how repealing Section 230 leads directly to provable solvencies, because we can show that in a media sector that is not protected by Section 230, these lawsuits led to irresponsible companies immediately and actively taking responsibility for misinformation. And with that, we move on to point 5, another pro point. Section 230 is being weaponized to prevent content moderation. So we just talked about how Section 230 removes incentives that these companies would have to police their own content. And then we talked about some of the impacts of them not doing that. But to be fair, they do at least have the choice, right? If they voluntarily wanted to remove, bad content, they could do it. And obviously sometimes they do. Facebook, Twitter, YouTube, they all have content policies. They all have content moderation of some kind, even if it is too weak. But right now, there are actually state legislatures, particularly in Republican states like Texas and Florida, that want to curtail even the voluntary ability to police content. These states are passing laws that limit the ability of content platforms to remove potentially harmful content based on what they describe as like political viewpoint bias. So for example, Texas House Bill 20 would prevent, say, like Facebook from removing or flagging posts with misinformation that falsely claims the 2020 election was stolen, because that would be like a political position. These companies in turn are responding with lawsuits that say, whoa, 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 you can't do that. You can't tell us what we have to allow on our sites. You're the government. We're a private company. We have First Amendment rights to speech. You can't come in and tell us that we can't remove stuff. Part of free speech is the government not being able to force you to say things. But federal courts, and this is the key part, federal courts are responding to that by saying, hold on. What do you mean you have First Amendment rights? First Amendment rights only apply if you're a speaker. And under Section 230, Congress has said that you are not a speaker. You're just a platform. You're supposed to be neutral. You're supposed to stay out of it. You're immune from lawsuits for what gets posted on your site. But so you can't have it both ways. You can't say, oh, I'm immune from lawsuits for what I do allow because I'm not a speaker, and then turn around and say, oh, but states can't tell me that I have to allow certain content because I'm a speaker and I have First Amendment rights. And this is all summed up really well in a piece from the Congressional Research Service in September of 2020. I'm not going to read all of it, but basically, if you look at it, what it says is that the Fifth Circuit Court of Appeals looked at a challenge to one of these laws, the one in Texas, and it actually said that no, you don't have First Amendment rights, for example, online platform, right? Because Section 230 says you're not the speaker. You're just a neutral platform. So what we have here is the Fifth Circuit Court of Appeals, which is just one level below the Supreme Court, saying Section 230 means that you, internet company, do not have First Amendment rights to resist state regulation. And the impact here could be mind-boggling. If states can tell Facebook or YouTube or Wikipedia what they have to allow, basically, the most extreme states on the left or the right could make up rules on content moderation, algorithms, and everything else for everybody. So if one state, say Texas, decided to pass a law saying you can't take down conspiracy theories about Democrats drinking the blood of children because, hey, that's a political opinion, or you can't take down blatant misinformation on COVID, then that could become the default rule for everybody, because as these courts are saying, these companies don't have First Amendment protection to allow them to curate their content. They're just neutral platforms. They're not speakers. Anyway, I think this is an interesting sub-point type argument where you basically say, look, according to the second highest court in the country, Section 230 means that Facebook, YouTube, Wikipedia, and others don't have First Amendment rights as speakers. They're just neutral platforms. They're not speakers, which means that the most extreme state legislatures can tell them what they have to allow to be posted, which not only means that they don't have to do moderation, it means that they can't do moderation if these states don't let them. And that is sort of a sub-variant of the content regulation argument that I think a lot of people won't see coming and might not be able to respond to. Okay, and so with that, let's shift gears and look at our last pro point, point 6, Section 230 grossly overprotects. The basic idea here is that Section 230 is sort of based on this outdated, almost quaint notion of online content from back in 1996, where, you just sort of start up an online forum, like website, like a message board. Maybe it's about like baseball or knitting or something. And, a few people post some stuff and a few users scroll through it and they just see whatever happens to be there on the front page at the time. And you, as the proprietor, are basically just a passive observer. In most cases, you have little or no say on what people see. So in this quaint little 1990s internet world, maybe it kind of makes sense to absolve you as the proprietor of any legal responsibility for what gets said. But that's not what the online world looks like today, is it? Social media companies basically farm billions and billions of pieces of content from their users and turn them into their product. Using algorithms. They show you what they want you to see to keep you engaged and keep them making money. And yes, it is almost always created by other people, but there's so much of it out there that the decisions about which specific items you get presented with in your feed, that really is the content. The company's algorithm and its decisions, if they say, for example, keep sending you fashion influencers as opposed to like the posts of old friends, that is a form of speech. Choosing what you see is a form of content, is a form of speaking. It's a very powerful one. And the problem is that Section 230 immunizes these companies for what clearly are substantive decisions about what to show you. And what makes matters worse is that these decisions often promote some very harmful tendencies. So for example, this is from Georgia Wells in the Wall Street Journal of 2021. And this is from an internal presentation at Meta, which is, basically Facebook in 2019, in which they acknowledged that their algorithms, their content presentation was causing mental health issues for teenage girls. 32% of teen girls said that they felt bad about their bodies. Instagram made them feel worse. Teens blame Instagram for increases in the rate of anxiety and depression. This reaction was unprompted and consistent across all groups. And these harms from toxic content have real-world impacts, according to Damian Gale in The Guardian of 2021. Among the most concerning findings was that among users who reported suicidal thoughts, 13% in the UK and 6% in the US traced them back to Instagram. Another transatlantic study found that more than 40% of Instagram users who reported feeling unattractive said the feeling began on the app. About a quarter of the teenagers who reported feeling not good enough said it started on Instagram. And it's certainly not just teenagers or self-image that these platforms exploit. This is from Kevin Zhao at UC San Diego. We cited this earlier, quoting a former Facebook manager, right? And we saw this before, but basically this was about how Tim Kendall says, we use extreme information. We use shocking images, graphic videos, and headlines that incite outrage to keep people coming back to the platform. So when your far left-leaning aunt only sees tweets that attack like fascist conservatives that make her angry, or your far right-leaning uncle only sees Facebook posts that make fun of woke leftists and make him angry, that's the algorithm at work. That's intentional decision-making by these companies to keep them coming back. Harming mental health, sowing division, all to keep people engaged, looking at the site and selling more ads for the company, basically. And this works on the same principles as other forms of addiction, like drug addiction, gambling addiction, you name it. And this is just a piece from the Addiction Center called How Social Media Affects the Brain. And I'm not going to read it, but as you can see, there is well-settled information and evidence out there about how these algorithms and these content feeds operate to get people addicted to the content and thereby change their behavior for the worse. Now, what we say as the pros, look, when cigarette companies intentionally made their products more addictive in the 80s and 90s and gave people cancer, you know what? They got sued. Courts awarded the plaintiffs in those cases billions and billions of dollars. They still award them billions of dollars even today in damages. But when big tech companies intentionally make their products more addictive to foster suicidal tendencies, political divisions, and other harms, nothing happens. They're immune because of Section 230, which was a law that was built, Judge, you would say, for an internet that no longer exists, for these small forums with unfiltered content, as opposed to these carefully curated streams that companies like Meta, Twitter, and Google create and establish and curate to keep you coming back and keep them making money. These companies make choices and write algorithms to harness content to make hundreds of billions of dollars. That is a powerful and lucrative form of speaking. And unlike all these other companies in every other field, they shouldn't have absolute immunity from the consequences of what they say and what they present to you from other people. All right, so with that, let's shift gears now and take a look at the con. So as we start on the con, I want to group points 7 and 8 together into a larger argument that I sort of call the all or nothing argument. And the basic idea here is in a post-Section 230 world, online platforms most likely have two options to avoid getting sued into oblivion. And those two options are the exact opposite of one another. You either over-moderate and over-censor content, or you don't moderate at all. So the first option, and the one we're going to talk about in point 7, is to do what the pro thinks that these companies will do, which is tighten up their restrictions and moderation of harmful speech. The con is going to argue that to do that effectively and minimize their risk, these companies are going to have to err so heavily on the side of over-censorship that they're going to remove a ton of valid free expression. The second option that we'll talk about in point 8 is the exact opposite. In this world, online platforms look at the risks and they decide to take a completely hands-off approach to content moderation. They do this because under the old pre-Section 230 case law, which we're going to talk about, the decision not to moderate your content actually made courts less likely to treat you as the speaker or the publisher. It was when you started moderating that's what put you at risk of liability, because you started to look more like a publisher who was making content decisions. So in this world, Facebook and Twitter and YouTube just decide to let it be a free-for-all so that courts won't view them as the speaker or the publisher and won't hold them liable. All right, so those are the two diametrically opposed options. We don't know which one we're going to get, but let's delve into them both. So point 7 is the repeal crushes free speech. Now, broadly speaking, I think the crux of the con's argument on this topic comes back to the idea that as a practical matter, a true online forum for free speech, like a marketplace of ideas, just cannot exist in a world where these platforms have hundreds of millions of users, and every time one of them hits post on something that's inaccurate or unfair or mean-spirited, the platform faces the threat of a multi-million-dollar lawsuit. So this comes from Aaron Turf of the Foundation of Individual Rights and Education in 2023. Without Section 230, websites would be left with a menu of unattractive options to avoid lawsuits over their user speech. Many would likely change their business model and stop hosting user-generated content altogether, creating a scarcity of platforms that sustain our ability to communicate with each other online. Surviving platforms would moderate content more aggressively and maybe even screen all content before it's posted. That isn't a recipe for a thriving, free speech-friendly internet. If you think Twitter and Facebook go too far with content moderation now, just imagine how much more aggressively these platforms would moderate if threatened with liability for user speech. The basic argument here is simple. If you want, somewhat better, more thorough, nuanced content moderation, outright repealing Section 230 is not going to give you that. It's not going to result in these companies being a little more careful or a little more nuanced. Instead, they're going to do what they have to do to avoid lawsuits, and that's going to be a massive overcorrection. If there is any risk that your tweet or your Facebook post or your Instagram post or your Wikipedia edit or whatever is going to be controversial political speech that could result in a lawsuit, they're going to pull it or at least heavily suppress it. This overcorrection is basically inevitable in a post-Section 230 world because of the sheer scale of information social media is presenting. And this is from Will Duffield of the Cato Institute in 2021. It talks about how popular platforms review millions of posts a day, often with the assistance of imperfect software. At this scale, some innocent speech inevitably will be misunderstood, mislabeled, and removed. Over the past few years, major platforms' rules have become more stringent and expansive, prompting concerns about censorship and bias. Demanding that platforms assume liability for their user speech will at best exacerbate the accidental removal of innocent speech. However, it also runs the risk of limiting who can speak online at all. Digital intermediaries usually review speech after publication. Speech may be flagged either by users, human moderators, algorithms, and placed in the queue for adjudication. Section 230 allows platforms to remain open by default and worry about excluding misuse when it occurs, giving a voice to everyone. In other words, Facebook, Twitter, YouTube, and others would really have no choice but to remove first, or at least suppress first, and ask questions later. And by the time you were able to go challenge the removal of maybe your somewhat edgy but still valid tweet, it would no longer be relevant. There are plenty of other sources you can find on this. We'll talk more about some of the impacts later, like hurting speech in a marginalized group. But the bottom line is really simple. The first possibility in a post-Section 230 world is going to be hyper-censorship of speech by online platforms. Remove first, ask questions later. Now, as we said, the other possibility is the diametric opposite, which brings us to point 8, repeal destroys content moderation. So the other possibility, if you're an online content platform and Section 230 is repealed, is instead of trying to more aggressively moderate, you stop moderating it entirely, so that if and when you get sued, you can tell a court, hey, listen, even without Section 230, I am still not the speaker here. I just run a platform. I have absolutely no input into what these people here are saying. And this actually is a pretty reasonable legal position to take if you know something about the law prior to Section 230. And so this is from Alan Rosenstein with Brookings in 2023, interpreting the ambiguities of Section 230. I'm not going to read it, but what it basically talks about is a pair of major cases that happened right before Section 230 was passed. In one case, you had basically an online bulletin board that had no moderation whatsoever, and a federal court found that they were not the speaker for purposes of a defamation claim because they weren't exercising any control. Contrast, though, to another case called Stratton Oakmont versus Prodigy. Prodigy was a web service back in the 1990s. I remember it. They hosted bulletin boards. They had internet service. They were an internet service provider as well, right? And what happened in that case is that Money Talk sued Prodigy for basically saying what it said were defamatory things. And the court in that case said, well, Prodigy, you're different from that other case. You actually do go in and you do moderate the forum and you do control the content. So we're going to allow this company to sue you for defamation. And what this created was, as you can see in the quote, a perverse incentive for platforms just before Section 230 was passed to not moderate content, since it was Prodigy's decision to moderate that that made it liable in the first place, as opposed to allowing it to remain on the sidelines and not get sued. So in short, federal courts right before Section 230 were saying, look, if you start moderating content, we very well may treat you as a speaker. But if you don't, if you stay completely hands off, we probably won't treat you as a speaker, which will let you get that defamation lawsuit or whatever kind of lawsuit dismissed, even without Section 230. And this is something that modern day commentators predict would probably happen if Section 230 went away. So this, again, is from Derek Bambauer with Brookings in 2021. Neutral curation of political content presumably would require platforms to treat Republican and Democratic press releases the same way they do information put out by white supremacist organizations. The only way to achieve neutrality is not to filter information at all. This 100% hands-off approach would be bad for at least two reasons. First, it would require doing nothing about even the most racist, false, misleading, harmful, maybe even criminal speech. In other words, if in a post-Section 230 world you want to argue, hey, I'm just a forum, I'm not a speaker, the only safe way to do that is to step away from any editorial discretion whatsoever and just allow even the worst, most harmful content. But second, it also threatens the ability to have focused online communities. This, again, is from Aaron Turr from the Foundation for Individual Rights and Education in 2023. I'm not going to read it, but basically what it says is like one of the neat things about the internet is you can find a forum for anything you're interested in. Right? Not everything is just a general purpose aggregator like Facebook or Twitter. You can have, a site or an app or whatever that is about, again, baseball, knitting. You can have a family-friendly app. You can have something, the NRA has something about guns and shooting, whatever you want. In a world where we had to abandon moderation entirely, these places to gather for specific people with specific interests would be endangered, if not extinct. And as we'll talk about later, one of the worst outcomes of that would be like for marginalized groups who need a place, like a safe place to aggregate online and talk about stuff without the threat of, sort of general purpose harassment that you see on a lot of social media sites. Those would be the most endangered sites because they have to engage in some degree of moderation. They have to say, no, your post is not about, issues for like indigenous people. We're going to remove it. So if you can't moderate at all, you just can't do that, right? So anyway, these are the two opposite bad outcomes in a post-Section 230 world, the Scylla and Charybdis, if you will, if you're into, I guess, Greek mythology. You either control speech too much or you give up any control and let the worst content go unchecked. And good con teams are going to be the ones who can explain to the judge, look, repeal creates this perverse incentive to go to one extreme or the other. And even if we can't necessarily predict which extreme it will be, we do know that we're creating a world where a moderate, reasonable, nuanced approach is literally the most dangerous one. And it's the one people are most likely to avoid. Which direction they run in, we don't know, but staying in the center and taking a moderate, nuanced approach to content moderation is not what they're going to do. It's the most dangerous place to be. People who stay in the middle of the road get run over, would be a clever thing to say. So with that, let's move on and take a look at point 9, also in the con, repeal hurts the least advantaged most. So as much as Section 230 is attacked by big tech critics as protecting these giant corporations like Meta and Google, the truth is arguably exactly the opposite. Giant corporations like Meta and Google may be the only ones who could survive in a post-Section 230 world. They're the ones who could pay all of the thousands of content moderators and lawyers and probably lobbyists that they would need to avoid getting crushed by lawsuits if the blanket protections of 230 did not exist. Section 230 protects the big and the small, the popular speech and the unpopular speech, the niche and the mainstream, but in particular, it protects the little guy or the little girl or the little person. The nonprofit like Wikipedia, the activist group, the startup that might one day grow into a viable competitor to the big boys. These are the people who would get absolutely crushed in a world of unfettered liability, which means, according to the con, if you want to ensure that the internet and social media become a true corporate oligopoly where minority views are excluded, well, there's actually no better way to make an oligopoly than to repeal Section 230. So let's start with the general idea that Section 230 protects the little guy. This is from Jessica Corbett at Common Dreams in 2020, and I'm not going to read all of it here, but it points out that, we're not just protecting big companies, we're protecting small companies and individual users, right? If you, for example, forward an email that's defamatory, or if you retweet or repost something that's defamatory, you cannot be liable for it. Same point is echoed here in another source by Jason Murdoch in Newsweek in 2020. And it says, look, right now you can, without any worry for liability, retweet anything you want. You can forward any email that you want. You can, share whatever content you want. In a world without Section 230, you, the individual person, student, regular person at work, whatever, you're going to have to start worrying about whether you could be liable for somebody else's speech. So let's imagine that you're like a student activist and you're opposed to like racism, anti-Semitism, things like that, and you retweet or you share a very harsh criticism that somebody else made of Elon Musk, accusing Musk of anti-Semitism after he had that tweet where he agreed that Jewish communities hate white people, which is, ridiculous, of course. Well, under Section 230, Elon can't sue you. It is 100% barred. You are 100% safe. There's nothing he can do to you. In a world without Section 230, who knows? If you draw Elon's attention and his lawyer's attention, maybe there's a legal argument that would protect you. Maybe there's a First Amendment right or something like that, but maybe there's not. Maybe in one state, sharing that tweet would be okay. Maybe in another, it wouldn't be. So you're a broke college student who's just trying to go out and share some information to oppose racism. You're a student activist. If you get sued by Elon Musk or whoever for sharing some information online, the cost of defending yourself alone, even if you win, is going to completely bankrupt you. And I know, I've worked as a lawyer in the private sector. I know how much they cost. So you know what you're going to do in a post-Section 230 world? You're probably going to think really hard as an activist or an individual about criticizing a rich or powerful person online. And in many cases, you may just not do it, which hurts the causes of all kinds of marginalized people. It hurts the free marketplace of ideas, and it just chills the ability to have a free exchange of information. Now, turning back to the issue of companies and platforms, we also see that Section 230 is essential to new competition. This is from Jennifer Huddleston with the Cato Institute in 2022. And what it talks about is without Section 230, or if the law were significantly narrowed, concerns could be expected to proliferate as platforms face more litigation and the accompanying costs for content moderation decisions. Given the volume of user-created content hosted by even modest-sized platforms, newer and smaller internet services would likely face far more litigation around their content moderation than they would be able to afford. These significant unrecoverable costs would impair the ability of new platforms to compete. Larger platforms are more likely to be able to attract the funding and legal resources necessary to defend themselves. Or to put it more succinctly, again, this is from Jessica Corbett at Common Dreams, repealing 230 would also forever solidify the monopoly power of the largest tech companies like Facebook and Google, who will be the only ones with enough money and lawyers to navigate a world where they become liable for users' posts. And this concern that smaller players would literally be run out of business is absolutely not hypothetical. It is real and demonstrable. And the reason we know that is because, remember, we said Section 230 has some exceptions. And one of them is for intellectual property laws like copyright lawsuits. Liability is allowed in those cases. And in those areas of exception, we have seen small companies get run out of existence. So again, according to Jennifer Huddleston, so what it talks about here is that under the Digital Millennium Copyright Act, you can actually be sued as a platform if you allow your users to post copyrighted information. And it talks about how we actually have seen small companies sued into oblivion. The video hosting site Veo, I think that's how you say it, but I wouldn't know because the company was run out of business by these copyright lawsuits, have found themselves bankrupted after defending bogus claims. So in a space like online videos where copyright is a big issue and where there is an exception to 230, there's no 230 protection for like copyright lawsuits, we do see smaller competitors getting sued out of existence. And we see one company, the platform we're on right now, YouTube, dominating the entire field. I hope that doesn't get this video like delisted or pushed down in the algorithm, but we'll see. And again, the impact of Section 230 here is twofold. One is just generally that competition is good. We want consumers to have choices. You can find many examples of that. But the other, I think, even more important impact is that Section 230 protects the ability of the marginalized to be heard online. Again, from Jennifer Huddleston. In some cases, the audience that a new platform seeks to serve is fairly narrowly tailored. This flexibility to tailor content moderation policies to the specific platform's community of users, which Section 230 provides, has made it possible for websites to establish online communities for a highly diverse range of people and interests, ranging from victims of sexual assault, political conservatives, the LGBTQ+ community, and women of color to religious communities, passionate stamp collectors, researchers of orphan diseases, and 1,000 other affinity groups. Changing Section 230 to require websites to accept all comers or limit the ability to moderate content in a way that serves specific needs would seriously curtail platforms' ability to serve users who might otherwise be ignored by incumbent services or traditional editors. Thanks to Section 230, websites can more comfortably host conversations on underreported or underdiscussed issues such as sexual harassment at the advent of the Me Too movement without fear that they could find themselves liable for their users' content. And then finally, as a sort of change of pace, I have this written down as Repeal will destroy Wikipedia, Reddit, and crowdsourced knowledge. So in short, this is a little bit of a niche argument, but I think it's a really powerful, concrete impact that you can put in front of judges, whether it's in the case or in rebuttal or something like that. And the argument here is that the primary benefit of online speech really isn't just sort of doom scrolling on Facebook or Twitter or Instagram. One of the biggest ways that we benefit, and one of the biggest changes to the world since I was a kid, is the availability of crowdsourced but still organized and usable information on pretty much any topic that you can imagine. In other words, Wikipedia, and to a lesser extent, other sites like maybe Reddit or similar sites. Now, some like Wikipedia are nonprofits, and they can't afford massive litigation. Others are for-profit, but not very profitable, like Reddit, and they probably also can't afford it. And there is a strong argument that Wikipedia may be the single most important resource on the internet, and it is arguably the most dependent on the protections of Section 230. Wikipedia allows anybody in the world with expertise on any subject to share their knowledge with the whole world, whether it's quantum physics, some obscure old movie, some obscure aspect of music theory, the little town they grew up in Minnesota, whatever. That immediate, fairly organized access to knowledge of countless people is something that did not exist when I was a kid, and it indisputably makes the world a better place. You very well may have gone to Wikipedia. Your judge may have gone to Wikipedia if they're a coach or something, to learn about what Section 230 is when you first started out on this, and you got a quick, pretty good summary of it in a way that you just could not have gotten in a world before Section 230. And repealing Section 230 endangers Wikipedia and sites like it more than anybody else. And you don't have to take my word for it. Just listen to Wikipedia's own general counsel, Michelle Paulson, in an interview with the Electronic Frontier Foundation about Section 230. And we have it right here. The question is, what would it mean to Wikipedia and Wikipedia's community if you could be held legally responsible for all your users' actions or posts? Answer: we probably wouldn't exist anymore. Simple as that. Lawsuits are costly when you win, but they're even more costly when you lose. If the Wikimedia Foundation could be held legally liable every time there was a good faith and accuracy on its projects, we would have most likely been sued out of existence pretty early on. We would have never had the opportunity to grow into what we've become, which is the largest repository of free knowledge in the world, accessible to all. And there's a similar argument for Reddit, which despite its, many flaws, does allow people with very specific interests to find forums where they can get specific answers to specific questions. Just yesterday, I was playing a video game, Baldur's Gate 3. It's a fantastic game, but it's really complicated. And I was trying to get this question answered about a really specific part of the game. And when I searched for it on Google, it immediately took me to Reddit, and a person had an answer there with photographs and a step-by-step guide of how you get through this section of Baldur's Gate 3. Anyway, Tate Ryan Mosley in the Technology Review of 2023 has this piece about how Reddit's general counsel also believes that they're threatened. And I'm not going to read it, but he points to lawsuits in which Section 230 has protected Reddit from liability because they do allow their content to be curated. Like upvotes and downvotes move it up and down, and that is interacting with the content. So anyway, I think the bottom line here is there are a lot of good impacts about how repeal would actually hurt the marginalized, the nonprofit, the startup competitor, and in particular would hurt these sources of information that make us more knowledgeable about everything and aren't wildly profitable. Again, Wikipedia is a nonprofit and can't afford to fight these things. And I think including those kinds of impacts is a necessary strategy on most con cases. And so with that, let's turn to the last major point, which I have as point 10, amend it, don't end it, ? I think the basic idea on this last point is that even if Section 230 is flawed, simply throwing it out via repeal is by far the most irresponsible and worst way to address those flaws. In other words, targeted reform is better. And that's partly because of the unpredictability and the chaos that we've already talked about. As we mentioned, you simply cannot predict what rules these courts will make in a post-230 world. They are dramatically different, diametrically opposed to one another. So no matter what outcome you want to see from Section 230's repeal, Judge, you don't know if you're going to get it. You get a dice roll. With targeted reform, you can. But there are some problems with this argument, and that's why I put a question mark after it. I went from thinking as I prepared this video that counter advocacies were going to be a really strong strategy for the con to thinking maybe not so much. But I still wanted to put it out there and walk through it because when you look at the real world literature on Section 230, a lot of what you would consider con type sources is talking about reform as opposed to outright repeal. So it would not be surprising at all to see a lot of con teams make some kind of argument about reform. Now, right off the bat, let me acknowledge this argument would be what you would call a counter advocacy approach. And we've talked about this before on the channel. And I know that in some circuits and with some judges, the idea of a counter advocacy in PF is seen as just contrary to NSDA rules. I have explained several times that I don't see it that way because frankly, that's just not what the rules say. The rule incidentally comes from Section 4 on page 25 of the NSDA manual, the section on public forum, and we'll pop it up on the screen. But as you can see, the rule prohibits both plans and counter plans, so both sides are barred from those, but it does expressly allow both sides to offer generalized practical solutions. So what is the difference between a plan and a counter plan and a generalized practical solution? Well, the rule says that the former, the plan/counter plan, is a formalized comprehensive proposal for implementation. Again, this applies to both sides. So the pro is advocating for repeal. So presumably repeal is not a formalized comprehensive proposal for implementation because if it were, the pro literally could not win. Well, if repeal is general enough to allow it in the round, I would argue on the con that a counter advocacy of reform it, amend it, don't get rid of it, that also has to be generalized enough to add. Look, I get it. Even though I think that you can win this argument in front of an open-minded judge, I've seen teams do it. I've voted for teams who did it. I've seen other judges vote for them. We do have to acknowledge some issues with a counter plan or counter advocacy type argument. First, some judges are just not open to it, right? They just believe that PF flat out bans counter plans and that's it, and they won't vote for it. And that's something you have to take into account. And second, even if the judge will listen to it, the idea that it's against the rules is just one more thing that you have to win and spend time on. Sometimes it's worth it. Like on the student debt topic, I thought there were a lot of good counter advocacy options like Pell Grants and free college and so on. And so I thought it was worth it. On this topic, I'm not so sure that the options that you have are good enough to take the risk of running like a counter advocacy. A lot of the reform proposals that are commonly cited for Section 230 have a bunch of their own problems and trade-offs and not a ton of unique benefits. So, for example, one of the most commonly cited reform ideas was the proposed PACT Act of 2020, which is described by Nandita Bose and David Shepardson with Reuters in 2020. And basically what it would do, as you can see here on the screen, is it would require online providers to have like a complaint process. And if you received a complaint about a specific post and then you didn't take it down, or if the government brought a complaint, like a lawsuit against you, then you would not have immunity in those cases. And look, by the time you're able to work out all of these details and explain how this specific piece of legislation works, you're really looking at something, honestly, that looks a lot more like a detailed, nuanced proposal that does sound kind of like a counterplan. So you can't just run in and say reform it. You have to specify how to reform it. And by the time you're doing that, I think there's a decent argument that, yeah, that's kind of starting to look like, you know, a counterplan, and you put yourself in a difficult position that you have to argue back from. So anyway, the takeaway here is I think you're going to find plenty of really smart think pieces out there with like smart people talking about how they would reform Section 230. And I think in the real world, that's definitely the right answer. And you may very well run into con teams that pick one of these and run it, and you'll want to be, frankly, prepared with rules arguments and maybe theory arguments about why that is a counterplan and why that's something the pro can't do in PF. In terms of whether you want to run it on the con, again, I'll say targeted reform undeniably is the better option in the real world, but I just think in this case there's just too many obstacles. If you're going to be specific enough with it, again, it starts to sound like a counterplan. So I was really crazy about this counter advocacy argument at the beginning. I'm not so much now, but I wanted to kind of flesh it out, and so there you go. Anyway, that is it. All 10 points covered. I really do want to, again, thank Devin and Tanner for all their good work on this video. Thought we had some really solid research this time. Hopefully you can put it to good use on the first topic of 2024, and we will see you back here with all three of us, hopefully, in just 1 month on whatever the February topic is. Until then, as we always say, remember that debate is for everybody. So work hard, have fun, and Hail State.